Hi guys, welcome to my channel. My name is Diana Romanovska. I am a certified family law specialist practicing family law in the Bay Area, California. Today I would like to discuss Valerie Bartinelli divorce from Tom Vitale. And it happened so quickly. They were divorced after 1 year she filed for divorce. First, she filed for legal separation. 6 months later, she filed for divorce. Why is that? So when people don't want to get right into divorce, but they want to start the process going, and perhaps sometimes they don't even have a residency requirement, meaning you have to be a resident of the county for 3 months and then of the state for 6 months in order to file for divorce. So that's number one. And sometimes it's a moral thing. I want to get things moving without filing for divorce. So she filed for legal separation in May 2021. And then after 6 months, it appears that she met the residency requirement in the county. Then she converted it to divorce. Her husband at that time, he claimed that their prenuptial agreement is not valid, where there was a waiver of temporary and permanent spousal support. He requested attorney's fees and he requested spousal support. This case was settled with a private judge. But what do we need to know about prenuptial agreements? They're upheld most of the time. But when someone is challenging it, it creates, especially for people like Valerie, celebrity, it creates noise. It creates publicity that someone doesn't want to have, and it's better settled in private court, in private setting where nobody has access, television cannot report about it, nobody can obsess about it. So what he created is very damaging to her well-being, challenging the prenuptial agreement, which means even though it's potentially valid, it creates a lot of noise. So what she did was a tactical move. She filed for bifurcation status only. Bifurcation status only is a thing that allows people to terminate marriage before dividing all other assets. And tactically, it's done when someone wants to be, done with that person. I want to be single. I want to be done. It creates an emotional distance. It creates single status. In most cases, the judge will grant that request, except in some situation where it wasn't granted. And I can only speak from my experience. In one situation, it wasn't granted when one spouse wanted to purchase an expensive real estate with or without separate property money or community property money. The judge just didn't want that spouse to use single status to avoid having the other spouse sign interspousal deed transfer. So as you know, when someone is married and buys in California real estate, it is required to either sign it together jointly, or that the other spouse who is not on the title would sign interspousal deed transfer to make that person who is the owner the sole owner of that property. So in that case, the judge denied bifurcation. In second case, the judge denied bifurcation was when a spouse abducted children to another country and then filed for bifurcation. So the judge said it was not in good faith. The request was denied. It wasn't even explained. It was just denied. So let's talk a little bit about prenuptial agreements. I had a case where the judge ordered temporary spousal support while the prenuptial agreement was challenged. So the prenuptial agreement said no spousal support. The judge orders spousal support and sets a trial date for discussion, decision, whether or not the prenuptial agreement is valid. And I have heard from many other lawyers that the spousal support, temporary spousal support, is not respected by the court, the waiver, and still granted temporarily. So the second topic is attorney's fees. Let's say he challenged the prenuptial agreement Tom Vitale challenged the prenuptial agreement, and then the court said it's valid, then Valerie would be entitled to prevailing party attorney's fees, because usually each prenuptial agreement says if you challenge my prenup and I win, I get all my attorney's fees back. So I think she did a wise thing by making the decision to have private judge discussion and resolution and settlement, because he might not be able to afford her attorney's fees. We don't know what his situation is. So, but there is two types of attorney's fees: the prevailing party attorney's fees and need-based attorney's fees, which is 2030 Family Code section, when someone has less access to funds, has less earnings, then that financially less privileged party can ask for attorney's fees. And that's what he did, I think. So he checked off attorney's fees. And the court could have awarded, depending on the complexity of the case, if it went to court, some of his attorney's fees. Usually it's between 50 to 80% of incurred attorney's fees at the end of the proceedings. Once the divorce is final, the court will look at how much was awarded initially and how much was actually spent, and it's not 100% reimbursed. Morton case of appeal in 2018 states that at the end, the court has no discretion to deny attorney's fees if there is a huge discrepancy in assets, access, and income. So that's another wise move, why I think she probably had to pay him a lot of money to keep this out of court. I would assume. We have no information. It's all private. That's why it's called private judge. And one thing I forgot to mention in bifurcation, when someone bifurcates the status, everything else, when I say everything else is reserved, meaning, let's say he was on her health insurance, then she has to pay for his health insurance if he were a dependent, if she were employed, let's say. Inheritance rights. If someone is divorced, then they have no right to inherit the assets. But in bifurcation, we check off all the boxes and say it is as if we're married, but technically I'm single. So I think I covered everything. If you would like to know more or ask more questions, ask them down in the comment section below. Like the video, subscribe, and I will see you in my next consultation. Bye!